Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update on the Delhi Chief Minister Arvind Kejriwal's plea before the Supreme Court. Kejriwal has challenged his arrest by the Enforcement Directorate in the alleged Delhi liquor policy scam. The Supreme Court is considering the question of releasing him on interim bail to campaign amid the upcoming general elections. The bench of Justices Sanjeev Khanna and Dipankar Datta heard the matter today. Solicitor General Tushar Mehta, appearing for the Enforcement Directorate, vehemently objected to the grant of interim bail on the ground of Lok Sabha elections. He submitted that Kejriwal avoided ED summons on 9 occasions and could not now be permitted to press election campaigning as an excuse. He said that the granting of interim bail would set a wrong precedent, as it would give the idea that political leaders are a class apart. To this, the bench said that it could not treat an elected chief minister as a habitual offender. The court also questioned ED's delay in the investigation. During the hearing, Justice Khanna made it clear that the bench was not inclined to allow Kejriwal to attend office and sign official files if he was released in the interim in view of Lok Sabha elections, as allowing him to perform official duties would have a cascading effect. Responding to this, senior advocate Abhishek Manu Singhvi, appearing for Kejriwal, offered an undertaking that he would not sign any official files subject to a condition that the Delhi LG does not stop official work on the basis that the CM has not signed the file. The Supreme Court bench of Justices Hima Kohli and Ehsanuddin Amanullah today continued hearing the contempt case against Patanjali. If you remember, last month the state had suspended manufacturing licenses of 14 products of Patanjali and Divya Pharmacy and had filed a criminal complaint against the company, its managing director Acharya Balkrishna and co-founder Baba Ramdev under the Drugs and Magic Remedies Act. Today, it was pointed out that even though the licenses were suspended, its misleading advertisements were still available on the internet, websites and on various channels. The counsel for Patanjali informed the court that a barrage of their ads were posted on social media and that by the next date they would come up with a complete plan. The bench also issued notice today on the application filed by Patanjali MD seeking action against alleged offending statements made by the president of Indian Medical Association in an interview given to the media. It is alleged that the IMA president criticized the Supreme Court's observations regarding the need for IMA to take action on complaints of unethical practices by allopathic doctors, and he called it vague and unfortunate. While issuing notice, the court asked the IMA to file its response. Also, regarding the letter sent by the Ministry of Ayush to all states and union territories licensing authorities asking them not to take any action against ads pertaining to Ayurvedic and Ayush products under the drugs and cosmetic rules, the central government today said that it will withdraw the letter forthwith. The additional Solicitor General pointed out that at least 8 to 9 writ petitions challenging the rule were filed before various high courts. The bench, however, noted that the judgment had not been delivered in any of those cases. After facing criticism from the court, the centre decided to withdraw the letter. In another important update, a bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra today heard the petitions filed by the state of West Bengal, the School Service Commission and certain affected employees challenging the judgment delivered by the Calcutta High Court last month, invalidating 25,000 SSC jobs across government and aided schools on the ground of fraud. The court today modified its earlier interim protection, which was granted against the CBI from further investigating persons involved in the state government's approval of illegal appointments. The court has now allowed the CBI to continue the investigation. However, it has clearly expressed that no coercive steps shall be taken. The court today also said that temporary protection granted by the court in November 2023 would continue. This order protected the appointments for 6 months while the High Court continued to adjudicate the matter. But the bench today also said that anyone unlawfully appointed and retained due to this order must refund their entire salary from the date of the order until the final judgment. With this, the matter is now posted to 16th July. Stay tuned. Coming to an update on the writ petition filed by State of Karnataka alleging that the centre was denying it financial assistance for drought management under the Disaster Management Act of 2005 and the Manual for Drought Management. Earlier, the Attorney General R. Venkataramani had informed the court that there was no longer a need for argument as the Union government solicited the Election Commission's clearance for dealing with the matter and had been granted the same. The Attorney General had further submitted that the needful would be done expeditiously. Last week, the court had directed the centre to submit the report of the interministerial team. Senior advocate Kapil Sibal, appearing for the state of Karnataka today, objected to the report submitted by centre and said that there were factual errors in the report. Accordingly, the bench of Justices B.R. Gavai and Sandeep Mehta posted the hearing to July. While deciding on a plea of Aam Aadmi Party MLA Amanatullah Khan against the action of Delhi police declaring him a bad character by opening a history sheet against him, the Supreme Court today modified the direction of the Delhi High Court to the extent that details of Khan's minor school-going children and his wife, against whom there was no adverse material, will not be included in the history sheet. The Delhi police, in a history sheet against Khan, had actually disclosed the details of his minor children and wife against whom there was no evidence. Moreover, the history sheet was widely publicized in the public domain. The court today said that extra care and precautions should be observed by police officers while ensuring that the identity of a minor child is not disclosed as provided by law. Let me tell you, when the police open a history sheet, it means they start keeping a record of someone's past involvement in crime. This record includes things like times they have been arrested, charged with a crime, or convicted. It helps police understand if someone has a pattern of breaking the law and can be useful for future investigations, or if that person is involved in another crime. The bench of Justices Suryakant and K.V. Vishwanathan today also clarified that history sheet is an internal police document and not a publicly accessible report. It cautioned the police officers that care must be taken to ensure that identities of only those minor relatives are entered in the history sheet against whom evidence is available. Further, while exercising its suo motu powers, the court directed all states and union territories to revisit their policy regarding making mechanical entries in history sheet, mentioning the details of the innocent individuals who hail from the social, economic, and educational disadvantaged backgrounds, along with those belonging to backward communities, scheduled castes, and scheduled tribes. A Delhi court has sentenced 5 individuals, including a Kashmiri couple, to different jail terms convicted for carrying out anti-national activities in India and for their affiliation with Islamic State Khorasan province, which is a part of the banned terror organization ISIS. Additional Sessions Judge Chanderjeet Singh of Patiala House Court sentenced the prime accused, a software engineer by profession, to 20 years of imprisonment. His wife was sentenced to 8 years of imprisonment. Among them is also a girl who was a journalism student at the time of her arrest. She was sentenced to 7 years, observing that she was highly influenced by the ideology of ISIS. The National Investigation Agency said that the accused persons instigated Muslims by coining seditious slogans and making graffiti at public places and highlighting the same on social and international media. The accused were also provoking some gullible youth to participate in anti-CAA protests actively. The Karnataka High Court has refused to quash a criminal case against the director of a company and his wife, who have been accused of using pepper spray on the complainant, who along with other security personnel allegedly attempted to interfere with their property. Pepper spray, also known as OC spray, causes severe irritation to the eyes, skin, and respiratory system, leading to temporary incapacitation. It is often used in situations where physical force is not desired, providing a means for individuals to protect themselves from threats or attacks. The petitioner couple in this case argued that they were forced to use the pepper spray in self-defense. After this, a criminal case was filed against them. They approached the High Court with a plea to dismiss the case, but the bench of Justice M. Nagprasanna denied the relief. The court said that there was no determination by any law in India with regard to usage of pepper spray being a dangerous weapon. But a court in the United States of America, in the case titled People vs. Sandal, had held that noxious chemical sprays like pepper sprays are dangerous weapons. While dismissing the petition, the court observed that the petitioner could not have used pepper spray as private defense, as prima facie there was no imminent threat or danger caused to their life. Therefore, the case at hand would require investigation in the least. A court in Uttar Pradesh's Bareilly district has convicted a woman for making false rape accusations in court against a man. In this case, back in 2018, the mother of the alleged victim woman lodged an FIR against a man alleging that her 15-year-old daughter was kidnapped and raped by him. Initially, the girl supported this statement, but in her cross-examination, she retracted from her earlier statement and said that the man had not raped her and that she gave a false statement on oath before the court under pressure from the policemen. She said that her mother deliberately filed a case against the man without any reason. In its judgment, the additional district judge Gyanendra Tripathi noted that due to her false statement, the man had to remain in jail for over 4 years. The court has now sentenced the woman to 4 years, 6 months and 8 days in prison, matching the duration for which the accused man had to remain behind bars. Additionally, the woman has been fined around 5,88,000, which will be paid to the man. Terming the incident to be a very serious situation for the entire society, the court said that the provisions specifically enacted for the protection of women were grossly misused by the alleged victim against the man by using police and court as a medium for achieving her illegal objective. And lastly, the Supreme Court today took up the issue of land allotment for the Bombay High Court building in Maharashtra. The court has directed the Maharashtra Public Works Department to conduct a structural and safety audit of the present Bombay High Court building in Mumbai before monsoon, since the heritage building is nearly 150 years old and construction of a new building for the High Court will take a few years. The CJI recalled a previous incident in the library of the High Court where a significant portion collapsed and fortunately no lawyers were present. Advocate General of Maharashtra, Dr. Birendra Saraf, presented details regarding the identified lands and the timeline for vacating them. However, the Chief Justice expressed dissatisfaction with the timeline, emphasizing the need for immediate action to hand over the lands to the High Court. The court noted that staff colonies existed on the allocated lands and urged the state to act promptly and ensure the relocation of the occupants. It emphasized the need for additional space for the High Court and chambers. The court also remarked that Goregaon is not a convenient location for the new High Court complex and Bandra is better for lawyers and litigants from all parts of the city. The matter is scheduled for further proceedings on 17th May. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.